Welcome back everybody to our studies in public international law. This video is going to be dedicated to the question of the sources of public international law. Now, a lot of textbooks and a lot of lecture commentary on this particular topic tends to brush over some of the more theoretical aspects of this topic, thinking about, well, what are the sources? Why are these the sources? Or is this a list that is exhaustive? Where do these sources come from? And people tend to sort of spend a very little amount of time examining that aspect of the conversation and moving on quickly to just examining each of them one by one. We will be examining each of them one by one, as you would probably imagine, in future lectures and looking at each source of international law in its own video. But I want to spend some time in this lesson focusing on some of the more theoretical ideas that underpin the sources of public international law. So we will outline what the classical sources are as defined by Article 38(1) of the ICJ statute. That includes international conventions, customary international law. We'll think about what customary international law actually requires, the idea of state practice, in addition to this concept that might be quite ethereal to some newcomers to international law, the idea of opinio juris. We'll think about what general principles of law refers to, subsidiary sources as well, such as the judicial decisions and the writings of the most highly qualified publicists, before thinking about some further considerations. Is this an exhaustive list? Should it be an exhaustive list, shifting from the sort of descriptive to the normative? Ought there be other sources of international law that we could include in this list? What about things like soft law? What about unilateral acts or declarations or the resolutions of international organizations? To what extent do judicial decisions represent really subsidiary sources? Should they not be more primary than that? That the article that is found in Article 38(1) gives them the respect that it is owed. Is there a hierarchy of sources? Is it to an extent the case that customary international law sits above that of conventions or vice versa? We will then spend some time thinking about the origins of this particular provision, where it comes from, and it comes sort of a TLDR, it comes out of the writings when it comes to the establishment of the League of Nations, and the Permanent Court of International Justice statute is very similar to that of the ICJ, and so the sort of origins of this particular provision dates back all the way to prior to the Second World War, to the aftermath of the First World War, and the League of Nations and the establishment of the League of Nations. We will then think about the theoretical approaches. What do we mean when we talk about sources? To what extent can we unpack this in a bit more detail? What about the delineation between formal and material sources, the legitimacy and consent regarding various different sources? Issues of consent within international law really strike at the heart of some of the sources of international law, specifically that of custom. As well as the sort of ideas of system integration, and then thinking finally by exploring a little bit of the theories of Kelsen, Kelsen's theories of international law. So fundamentally then, we can see that the Statute of the International Court of Justice says the following. Article 38(1), if you are to ask the question, what are the sources of international law, a perfectly correct and perfectly satisfactory answer to that question would be, well, look at Article 38(1) of the Statute of the International Court of Justice, where it says that the court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply international conventions, whether general or particular, establishing rules expressly recognized by the contesting states, international custom as evidence of a general practice accepted as law, general principles of law recognized by civilized nations, and then subject to the provisions of Article 59, judicial decisions and teachings of most highly qualified publicists of the various nations as subsidiary means for determination of rules of law. Now, the reason why we suggest that this is the sort of classic example of the sources of international law, the sort of classic definition, is because when you think about a dispute within public international law, one of the sort of places that a dispute may take place is in the International Court of Justice. So looking at the ICJ statute and thinking, well, what kind of things, what kind of bits of law, if you will, can the International Court of Justice apply to disputes that are submitted to it? Well, it's these 4 or 5 things. It's these various different sources. And so we suggest that these are the sources of international law. Beginning first then, international conventions. The word convention and treaty are completely interchangeable. A convention is the same as a treaty is the same as a convention. When it comes to international law, don't get that mixed up, by the way, for English law students with the sort of UK constitutional law. Constitutional conventions are not the same, but a convention and a treaty within the context of public international law are the same. And they are written agreements that are established between the states and sometimes between international organizations or states and international organizations. And they are established rules expressly recognized by these states. So that is what is required according to Article 38(1)(a). And what we see here is that essentially treaties operate on the basis of the consent of the parties. Essentially, a bit like a contract in English law or in domestic law, a treaty requires states to agree to be bound to them. All right. They may be bilateral in the sense that they are agreed upon between 2 states, like a bilateral investment treaty, for example. They tend to be heavily bilateral, or they might be multilateral in the sense that they are agreed upon by a number of different states. So, for example, all the various agreements associated with the World Trade Organization, the General Agreement on Tariffs and Trade, is a multilateral treaty. It is not just 2 states that have signed on to it. It is up to the time of recording around 147 states that have signed up to the World Trade Organization. They are often the primary way in which states can create detailed rules in specified fields. We will get to why this is the case in a second, because international custom is a little bit slower, it is a little bit more difficult to really put your finger on. Whereas a treaty, if you want to, for example, regulate an area of international law, then nothing is better than to just have a treaty that expressly states what the rules should be in accordance with the agreements upon states. So, for example, when the world community and the United Nations came together and wanted to see more heavy regulation or sort of cleaning up of some of the rules associated with the law of the sea, they came together and they created the United Nations Convention on the Law of the Sea. They created UNCLOS for dealing with maritime matters that are frequently cited in treaty law. Now, theoretically, there are lots of different areas of law of the sea that are also customary in nature, but nothing is better if you want to just have a very clear understanding of what is the law than to just put it in a treaty and to get that treaty agreed upon and ratified. Now, the statute of the ICJ itself treats treaty law or conventions as a first source, but there is of course a question about whether or not there is a hierarchy associated with this list. So just bear that in mind at the same time, and we'll get to that in a second. So treaties are the easiest sort of international law to think about. Now let's think about a more difficult one, the idea of customary international law. Now, Article 38(1)(b) states that international custom as evidence of a general practice accepted as law, and they define this as a primary source of international law. It is one of the 3 primary sources associated with this provision of the ICJ statute. Now, customary international law has some benefits over that of a treaty in the sense that you don't need state consent for it to be binding. Customary international law basically says that there are some rules that are so fundamental and so widely practiced by so many states in the world that that rule has become its own rule. It's crystallized and become its own rule, absent any agreement or any explicit recognition of a state agreeing to that particular rule. So a state doesn't necessarily have to agree to a rule that is customary in order for them to be bound by it. And it should also be noted as well that lots and lots and lots and lots of different rules that maybe originated from treaties have crystallized into customary international law, have sort of become both treaty and custom at the same time. So various aspects of the Vienna Convention on the Law of Treaties are representative of custom. So too are various different provisions within the Geneva Conventions when it comes to international humanitarian law. Things like the Genocide Convention, the vast majority of that is customary international law as well. Scholars have recognized that in order for you to have a custom, an international custom, for something to be customary international law, it requires there being two features. The first is state practice. There has to be a consistent pattern of behavior by states in performing that principle, okay, or in recognizing that as a principle. But there is an additional element that has to be associated with it, and this is the element that is sort of a little bit more confusing for some students. The first is this idea of state practice, very simple, very practical in terms of our understanding. It basically requires us to recognize that states are behaving in a way as if that principle were binding, which is the next position. So they have to not only be practicing a consistent pattern of behavior that can be recognized, but they have to be doing so with the consideration that the practice is legally obligatory. So this is sometimes known as the doctrine of opinio juris. It is essentially the belief that states aren't just doing a particular thing, they're doing that thing with the belief that in doing so they are following the law. They are doing so because there is a belief that it is legally required to do so. So, for example, if we were to just take some provisions, let's say some basic provisions of the Geneva Conventions associated with international humanitarian law, if a state is, and if there are enough states consistently behaving in a way that is consistent with that, with a rule of the Geneva Conventions or a rule of IHL, and they are doing so with the idea that what they are doing is legally obligatory, they are doing it because they think that it is legally obligatory, then this can give rise to the existence of custom in that particular era. And so you can see here that it is interesting in the sense that a custom can arise without the existence of a treaty, and therefore can bind states even if they do not consent specifically to that custom being a principle of law they have to follow in a treaty. So a treaty is beneficial in the sense that it clears up and it makes very clear and makes very obvious what the rules are that states are bound to, but it is limited in the sense that only the states that have signed up to a treaty have obligations associated with that treaty. But custom is very different in the sense that it's a bit more complicated. It's a little bit more confusing to find where it exists, to find out whether or not a rule has become customary. But once we have found that, it is binding onto all states, regardless of if they consented to it. So if it is a rule that came from a treaty, for example, the state in question does not need to actually sign on to that treaty if that rule has now become customary in nature. The third source of international law is arguably even more confusing than the second, in the sense that we're talking about general principles of law which are recognized by civilized nations. A little bit of archaic language there when thinking about the recognition of civilized nations. Of course, this harkens back to some of the sort of colonial and imperialist language that we see in the 1800s and the early 1900s, the delineation that is made between the civilized and the uncivilized peoples. However, what we see here are a variety of different principles of law which are drawn from a variety of different sources. One of the most important of these is the use of domestic legal systems. So, if a court in a domestic legal system has elucidated on a ruling about a particular case and has elucidated on issues of public international law, this can develop and be transposed into the international sphere as a general principle of law which is recognized by the civilized nations. Okay, so that is one instance where we can see domestic legal systems opining on international issues and transposing those issues into the international sphere. Additionally, they could be opining on principles of law which may have relevance in the international sphere. There is crossover in a variety of different ideas. So, for example, the principle of good faith, the idea of pacta sunt servanda, the idea that agreements must be kept. That is a principle that is very, very important in international law, but it's also important in domestic law, in sort of basic contractual ideas and obligations. The role of general principles, then, is primarily as a gap-filling exercise. When treaties and custom do not cover a particular situation, then it might be the case that a general rule or a general principle of international law may provide the rule that can fill in this area. And again, as I've noted, what we see here is a variety of different instances where the phrase civilized nations is, of course, historically rooted in the scholarship and in the history of imperialism. The idea that there was once a time in which international law was, in fact, conceptually divided between the civilized and the non-civilized states. That's a bit of an archaic and outdated principle that really doesn't have much popularity in this case anymore. In using an example, I've already mentioned pacta sunt servanda, but the principle of good faith is another illustration. The principle of good faith is referred to specifically in case law, in international case law, as a general principle of international law. You can see the statement by the ICJ president as well, which I'll get to in a second. But in the advisory opinion on the legality of the use or threat of nuclear weapons from 1996, they referred to the principle of good faith as one that is a general principle of international law. Let's then think about subsidiary sources then. So those are the three primary sources. And now the subsidiary sources are firstly judicial decisions. So the judicial decisions and the sort of teachings of the most highly qualified publicists. These are seen as not primary sources of international law, and in the sense that they create legally binding rules of their own, but they can almost basically determine or help a court to determine what the rules are. Remember that the context that we are exploring these ideas from is the context of the ICJ. Thinking about when the ICJ has a dispute on the docket, if you will, what kinds of things can the ICJ refer to when trying to resolve the dispute? That's how you're thinking about Article 38.1 of the ICJ statute. We're thinking about it as a sort of a useful tool for the ICJ to help determine disputes. So subsidiary sources, again, do not create legally binding rules necessarily of their own, but they can help determine what those rules are. They are, like I said, explicitly described by the ICJ statute as having subsidiary means or being subsidiary means for determining the force of law. So when it comes to judicial decisions, we're thinking about, of course, decisions of the ICJ, but also we should note that according to Article 59 of the ICJ statute, the decision of the court has no binding force except between the parties and in respect of that particular case. So you have to be very clear that ICJ statutes or the ICJ decisions relate specifically to those cases and to those states in which those decisions are, of course, situated. So whoever is in dispute, essentially, whichever states are in dispute. That is not to suggest, however, that principles and rulings and ideas from cases that aren't necessarily binding onto anybody else can't have lasting impact on the rest of the international community. They could, in those cases, elucidate new principles of customary international law. They could interpret multilateral treaties in a way that would ultimately have application if that treaty becomes a major part of a dispute in a future case. A really useful illustration that we can find there is, of course, when we think about the application of the Genocide Convention in a variety of different bilateral disputes. There are sort of a couple of cases in the late 90s, early 2000s, the Bosnia genocide case, or also the Croatia genocide case. They both have quite a lot of jurisprudence and quite a lot of explanations and unpacking of what it means to commit genocide and what the Genocide Convention essentially requires of states, such that now we're getting to a sort of a new generation of Genocide Convention cases with Israel, South Africa, with Russia, Ukraine, and also with in the Myanmar case. That those older cases might provide illustration for the court today on what the correct course of action is in coming to a determination of a dispute. So whereas, according to Article 59, the decision itself is only binding on the parties that are in the dispute, the rulings itself can still have longer lasting impacts, especially when we're thinking about either customary principles that might be in dispute in the future, or also treaty principles that might be in dispute in the future as well. You could also make it very clear that there are other judicial mechanisms. There's not just the ICJ in international law. You've got, of course, the older ad hoc tribunals of the Tribunal for the former Yugoslavia and from Rwanda. When we go and look at international criminal law in more detail, and international humanitarian law as well, we'll see that cases from the ICTY and the ICTR are very relevant. The determination of a non-international armed conflict, for example, is set out in the Tadic case by the ICTY. The ICC is also increasingly showing that it has a very key role to be playing when it comes to things like questions of head of state immunity, questions about fundamental issues of international criminal law, as well as fundamental issues about jurisdiction and universality of jurisdiction in international law, all of which are questions that are very, very controversial and very, very important. Again, the WTO, when it comes to trade issues, the Law of the Sea Tribunal, and there are a variety of others. ICSID, for example, UNCITRAL, when we're thinking about sort of investment dispute resolution. Moving on then to the second of these two subsidiary sources, we've got, of course, the teachings of the publicists. So these include things like academic writings, commentaries, broader scholarly works, the scholarly opinions that may be issued as declarations to a court in a particular dispute. They influence how scholarship has interpreted and developed rules, and that can be imbued in and sort of feed itself into judicial decisions that ultimately might have broader and longer lasting impacts. But it could also be impactful when thinking about reforming the law, the International Law Commission, and things like the signing and the negotiations of new treaties. One of the sort of big areas of international law that we're seeing developing in the sort of short term is treaties or a convention associated with crimes against humanity, a crimes against humanity convention, the extent to which that will ever be negotiated and ratified, and the kinds of things that need to be worked out in that regard. That's an area of new law that is gaining new ground. So with all this in mind then, let's think about this in a bit more of a holistic way. The first question we could ask is Article 38 exhaustive? Are the sources of international law that we have opined upon right here, are they exhaustive sources of international law? Well, there are potentially other sources, of course. It's not the case that there are just no other sources that could be thought of. And there are potentially other sources which are very important for international law, but maybe aren't expressed explicitly by the ICJ statutes. There is another question that could be asked in regards to this, is that does this list of sources that are elucidated by Article 38, does this list have to always be a static list of sources? Could we have a situation where there'll be new sources of international law in the future? Why not? This, as we will see when we look at the sort of origins of Article 38, it came from the sort of aftermath of the First World War and the establishment of the League of Nations in the 1920s. That's over 100 years ago. And so to what extent could we say that the world has changed since then? Even if we're thinking about the ICJ statute itself, that was the 1940s, that was 80 years ago. So to what extent could we say that time has changed such that there could be new sources that have developed that law might need to recognize? According to one of the former presidents of the International Court of Justice in 2019 at the 6th Committee of the General Assembly, they say that the court has shown a high degree of creativity by adapting and updating the sources of international law described in Article 38 of the statute to reflect the revolution of international law and realities of international life. Thanks to the jurisprudence of the court, unilateral acts of states are now well-established sources of international law. In the same vein, the court has established the important role of multilateral conventions and resolutions adopted by the General Assembly that can play in the emergence of customary rules of international law. So, essentially, what we're getting at here is that we have things like soft law, we have things like unilateral acts, and the resolutions of international organizations. None of these are explicitly cited per se in Article 38 of the ICJ statute, but one of the former presidents of the Court of Justice has said that no matter, essentially, we don't need to reform Article 38 necessarily because the court has done a very good job in using some of the ambiguities of the sources of international law, especially things like general principles of law, to recognize new areas that might gain greater ground and might be more important or might eventually be useful for the crystallizing of rules into customary international law. Soft law instruments, for example, a declaration, codes of conduct and guidelines. They're not treaties, they're not necessarily binding, and yet they can still necessarily influence state practice when thinking about aspects of international law. Look, for example, no further than the Universal Declaration on Human Rights. The Universal Declaration on Human Rights is not binding on states. It doesn't bind states in any meaningful way. However, it is very important because it was basically the framework from which we see actual international human rights treaties, like the Twin Conventions, the Twin Covenants, of the social and economic rights and the cultural rights as well. Social, economic, and cultural rights, as well as civil and political rights. The Twin Covenants that were established a good few years after the Universal Declaration, but nevertheless were influenced by the Universal Declaration. The same can also be said, of course, about the things like the European Convention on Human Rights, which also was sort of wrapped and mixed in with this new human rights language and this new human rights conversation that was had at the end of the Second World War. So we could also note, and as the president of the ICJ, the former president, observed, that resolutions of the United Nations General Assembly and the Security Council may play a role in the emergence of customary rules as well. We should also note that, of course, while already customary and while already found in some treaty obligations, preemptory norms and erga omnes obligations may also find themselves as recognizing as a sort of separate subset of customary international law itself. We'll get to what jus cogens obligations mean and what erga omnes obligations mean as well in future lessons, but this is a sort of question that is sort of twofold, because in one sense we're talking about this as an exhaustive list, but it can also be part of our conversation about things relating to the hierarchy of sources. It doesn't explicitly say in Article 38 that there is a hierarchy of sources, that treaties come first, then custom, and then general principles. It is sort of written, and it is sort of explanatory in the sense that Article 38 looks at a dispute and looks at all the different sources from which a dispute can be resolved. And so in that regard, you could argue that the ICJ might look first to treaties, and then if there's no law that can resolve the dispute in the treaties, then they might look then to custom, and then if there's nothing there, they might then look to general principles, and then finally, when all is lost, they might look to subsidiary sources. But the question about jus cogens obligations and the questions about erga omnes obligations, again recognizes that there are certain norms that are of such fundamental character that they will bind all states and can never be derogated from. And so jus cogens obligations, for example, are customary, automatically customary in nature, but they are sort of one step further, in the sense that they're, again, not a formal separate source of international law, but they seem to have a more binding quality. They seem to have a more fundamental character to them than that of just ordinary principles of customary international law. We'll get to that in more detail in future lessons, as I've noted, but it's an interesting thought to keep in mind when thinking about what Article 38 is actually doing and the kind of things that we can do with Article 38, given the sort of realities of the fact that it's quite an old provision. So this is just basically Article 53 of the Vienna Convention on the Law of Treaties that gives you some rules associated with treaties that conflict with jus cogens obligations of international law, and they say that a treaty is void if at the time of its conclusion it conflicts with a preemptory norm of general international law. For the purposes of the present convention, a preemptory norm of general international law is a norm accepted and recognized by international community of states as a whole as a norm from which no derogation is permitted, which can be modified only by subsequent norm of general international law having the same character. So basically, you can only change a jus cogens obligation with another jus cogens obligation. One example of this is, of course, the commission of genocide, the use of slavery, for example, or torture and other cruel punishments. You can't have a convention, for example, or a treaty or anything that gives one state the right to commit genocide against another state. That would be automatically void. It should also be noted that it is one of the single areas of international law, of law more generally, that is retrospective in nature, in the sense that if a future jus cogens obligation arises, then previous treaties and agreements that were signed and agreed upon before, those parts of those treaties would also be void as a result of this new obligation. So if, for example, there was a treaty that gave a state the right to commit genocide in the 1800s, or commit the equivalent of genocide in the 1800s, then with the existence of a jus cogens norm coming in the 1940s with the Genocide Convention, that would make that older treaty completely void and of no value. Let's then think about the origins then. What's the origins of the ICJ statutes of Article 38.1? Where did it come from? Well, its ancestral text, its original text, is, of course, as I've noted, the statute for the Permanent Court of International Justice, the PCIJ. This is, of course, the court that existed prior to the ICJ. It performed essentially the same role as the ICJ does today. It just was a lot less effective. The Statute of the Permanent Court of International Justice was adopted on the 13th of December 1920, and it contained its own version of Article 38.1, which lists the same sources of international law as we have in the current International Court of Justice. In fact, it was materially reproduced in the statute of the ICJ. It was basically copied and pasted from this previous statute. So if we want to find the origins of Article 38 of the ICJ statute, we have to go to the drafting process of this earlier provision, the drafting process of the Permanent Court of the of International Justice. The drafting process took place with an advisory committee of jurists. There had been a number of attempts previously to establish a formal list prior to the 1920s. And, for example, we see in a variety of different circumstances illustrations of what may or may not be sources of international law. The 12th Hague Convention of 1907, which was never ratified, by the way, just bear that in mind, was a convention relative to the creation of an international prize court. And again, it had within it provisions maybe associated with what could be sources of international law. Notice again that the reason for this, the sort of motivation for establishing a list of sources of international law is again in order to establish a mechanism for dispute resolution. that the ways in which we think about the sources of international law don't necessarily happen in a vacuum. They happen at the point at which we want to create a court that is going to adjudicate on disputes. There's going to be a court that adjudicates on disputes. Well, the first question that we should ask is, well, what sources can the court actually rely upon when a dispute arises? Now, the drafting process that is done by the Advisory Committee of Jurists, again appointed under the League of Nations, was quite heavily influenced by legal positivists. There was an attempt, there was the desire to try and identify the formal sources of international law. This was to identify more than simply what could be seen as moral or natural law foundations. And so it had a very legally positivist establishment in its early drafting process. A need for international law that went beyond the positive rules then identified with treaty and custom. By implication, the scope of international law could not be said to have been defined by positive rules, or at least not solely by positive rules. So there was a desire on this account, the account of the so-called 12 wise men of the Advisory Committee, to draft Article 38 of the statute. And so they did so, and they came to the conclusion that they did, that we see the sort of 4 or 5 sources that were established. Skip ahead then to the Second World War and the end of the Second World War. When the United Nations was established in 1945, the ICJ was again created as the principal judicial organ according to Chapter 14 of the UN Charter. And the statute of the ICJ incorporated a lot of the same language that we see in the previously established Permanent Court of International Justice. Now, the phraseology of the ICJ statute, again, of course, reflects as a result the language of the era of the 1920s. So things like this, for example, delineation between civilized and uncivilized nations, that was still language that was sort of appropriate in the 1940s. Don't make no mistake about it. But it is so antiquated now. It is seen as so antiquated now, partially because it is phraseology that comes from the 1920s, from the Committee of Jurists, the Advisory Committee of Jurists, in the establishment of the League of Nations, not necessarily in the establishment of the ICJ. The most prominent example, as I said, is the colonial context. If the 1940s was also a sort of a period of colonialism, with the sort of the winds of change beginning to take place, the 1920s was absolutely also a period of very extensive colonialism. The colonial holdings of the British Empire, for example, reached their peak really late 1800s, early 1900s, and especially after the acquisition of the mandate territories of the former Axis nations. There is a certain degree of nostalgia attached to Article 38 as a relic of the past. A number of scholars argue that world developments such as the end of colonialism and the emergence of new actors on the world stage had an impact on the currency of Article 38, although the nature of such an impact is uncertain. That's another factor that Fitzmaurice points out here in this passage, because you have to remember that the United Nations of the 1940s is a very different United Nations to that of today. The United Nations General Assembly, for example, of the 1940s was a lot smaller than the UN of today. Decolonization and the sort of end of colonialism, as well as the end of the Soviet Union in the 1990s, led to the acquisition of, or the creation of, hundreds of new states. And so it goes without saying that an international legal system and a world order that is established, for example, at the turn of the millennia in the year 2000 might look very different to the international legal system that we got and that we still hold on to, that was established at the end of the Second World War in the 1940s. Let's then think about some of the theoretical conceptualizations associated with these sources, okay? The first question that I want to ask is, what do we mean by sources? What do we mean, as a starting point, what are sources of international law? So, in the context of public international law, we see that Sources are those formal and material processes from which norms or obligations might arise. Given that this is what we mean by sources, to what extent does the ICJ statute, specifically Article 38.1, represent a truly exhaustive list? We've already been through this, but we can see Robert Kolb making a point that history has for a long time been a source of international law in a much larger sense than it is today. At the time of natural law doctrines, even in the 19th century, the references to historical rather than dogmatic arguments were extensive. Moreover, even at present, history displays some legal roles. It does so by way of a series of positive legal institutions which refer to historical aspects interrelated into the law. What's the point of bringing this particular passage up, again from the Oxford Handbook on the sources of international law? Well, it's making the point that legal history is, in a way, in itself, a type of source of international law. And when we looked a second ago about the sort of exhaustivity of the ICJ statute, we didn't even think about the idea of historical ideas, the idea of legal history as its own source. But we could do. We could theoretically have an examination of that as well. So, again, thinking about the idea of exhaustivity, but also thinking about the statement that we read previously from the ICJ president about how ingenious the ICJ has been in the sort of adaptation and the reformulation of the traditional sources in such a way, and relying on its ambiguity in such a way so as to incorporate other sources of international law. To what extent is that satisfactory enough? To what extent is that a satisfactory answer to the question of, well, should we not think about adding new sources or considering new sources? Or shall we just rely on the whims of the ICJ's jurisprudence to do that for us? That's an interesting question that you might want to think about. One of the outstanding assumptions underlying the sources doctrine goes almost without saying for standard accounts of international law. A doctrine of the sources presupposes an understanding of international law as a set of autonomous rules. Rules whose application is at least to some extent independent of political, economic, or other preferences of those applying them. So, what's interesting about this passage is that it really does strike at the question of the positivist approach, the turn of the positivists in the 1920s, the idea that we can, through legal positivism, formulate a collection of neutral rules that will be applicable in legal situations, that can be applied in quite a mechanical and in quite a divorced manner to that of the sort of socio-political and economic context that underlies them. And that this is a concept, an idea that was really heavily developed by the sources of international law. The assumption that we have a collection of sources, we have a clear list of sources of international law, implies that these rules, to an extent, can be detached as autonomous rules. They can be detached as separate from the geopolitical and the domestically political context from which they are being applied, from the economic context in which they are applied as well, and the social context in which they're applied. All of these are things that are assumptions that really are baked into a quite positivistic idea of international law as being formulated with very clear formal sources, but they're not necessarily, it's not necessarily the case. It's an assumption that may, in some cases, need to be questioned. Another dominant strand of the theory emphasizes the idea of consent when it comes to the idea within international law. One of the things that we will see when looking at international law, specifically when we look at treaties and when we also look at statehood, is firstly the idea of there being an equality of states on the one hand, but then secondly this idea that state consent and that the sort of permission of states is what is required for international law. Law is created by states, the international law is created by states, and it is that as the basis, as a sort of starting basis for binding rules. But theory also interrogates legitimacy of international law where consent may be limited. Why should states feel bound to rules that they don't consent to, even if they are customary international law, for example, customary in nature? Why should non-state actors be bound by those similar rules? How is authority generated beyond explicit consent? All of these are questions that are obviously very, very interesting. And again, I'm not going to answer in an introductory lecture on the sources of international law. But there are questions about that. When we think about, for example, the equality of states within international law, when we then interrogate this against the backdrop of sort of global hegemony and the way in which power is distributed among states within the international community, stepping our toes for a second into sort of international relations theory for a bit, we can see that certain states have a much greater say in rules of international law than other states. This might be when it comes to treaty negotiations. The rule of the powerful states are very, very influential. But it might also be the case when we think about the development of custom, when larger, powerful, hegemonic states have a greater say in the establishment of customary rules of international law. To what extent is it just then for smaller states that have less power on the international stage to be able to or to be expected to be bound to those same rules, that they don't necessarily have an equal say in its establishment? Again, that's a question for another day. Jurisprudential considerations might need to also be taken into account. For example, is international law derived from the natural law tradition or from legal positivism? As we have noted previously, the sort of codification of these sources come from a very positivist endeavor, come from a quite positivist backdrop. And so to what extent can we make considerations on that? Again, these are questions really for a philosophy of international law series. The point of this series is to provide you with an overview of public international law more generally, while taking into consideration some theoretical elements. So again, I'm going to park some of these questions here, but feel free to discuss some of them in the comments down below. Samantha Beeson is very inspirational and very important in thinking about the sources of international law. And they say that the concept of source is known to all legal traditions, whether it be domestic, regional, or international, originally used as a metaphor within particular stato-positivists' theoretical frameworks, and maybe thanks to the transformative potential of that metaphor, the concept has acquired some semantics of its own legal discourses. It's another interesting consideration that not everybody in international law are positivists. Not everybody ascribes to the position of legal positivism or to the same position of legal positivism. And so from that regard, given the fact that the sources of international law are fundamentally positivist in nature and originally come from this sort of metaphor of positivism within this sort of stato-positivist theoretical framework, to what extent should we reconceptualize our understanding of the sources of international law in that kind of way? Thinking then finally about some of the writings of Hans Kelsen, the Austrian jurist, who developed a theory of the sources wherein he viewed sources as instruments of law creation, and that this instrument of law creation was independent of sort of some kind of broader consensus or sort of metaphysics about law itself. Kelsen maintained the legal sources of international law, that they represented by custom and treaty, and that they had to be made available to international politics and substantively unrestricted instruments of societal change. Kelsen's theory of the sources of international law was based on the assumption of the hypothetical character of the law, that international law found its objective basis neither in posited meta-legal values nor in a consensus of sovereign state wills. So again, putting all this theory into sort of context and sort of coming to a conclusion here on this regard. When we think about the sources of international law, I want to just take us back to a deep understanding about this idea of exhaustivity, this idea of the fact that the sources of international law seem to have been created in a relatively archaic time period where the language of civilized and uncivilized nations was still very popular and very prominent, was still very much in the colonial context. The sources of international law, as adopted by the ICJ statute from the previous Permanent Court of International Justice, was created at a backdrop in a United Nations that looks very different to a United Nations of today. And to what extent should there be a reform to thinking about the sources of international law? To what extent should we think maybe that the sources are hierarchical in the sense that we have things like Jus Cogens obligations? To what extent could things like unilateral declarations and soft law instruments also be considered their own sources? And so to what extent can we see reform within international law, looking at the sources and looking at potential ways of thinking about not only incorporating sources that may currently exist that could be sources of international law, but thinking of a mechanism by which future sources that we might not even know about yet could also be incorporated. All of this is, of course, central to a theoretical approach to the sources of international law. The next lessons are going to explore these concepts in more detail, but really from a more procedural and more practical element. So we will talk in the next lesson about the law of treaties, and then we will think about customary and international law. General principles and subsidiary sources will be put sort of together in one single lecture. And then I will finish this topic by looking at erga omnes obligations and also Jus Cogens obligations. And then from there we will start looking at statehood.